I'm Rhys Rosser and I'm your first speaker for today on modern slavery legislation. Then Nick James is going to speak about the duties of an expert witness. And finally, Stan Rice QC is going to discuss charging in money laundering. What I'm going to look at in particular is the use of modern slavery as legislation, both before and during a criminal trial, with a particular focus on the national referral mechanism and the Section 45 defence. This Act was introduced in 2015, and that was by the then Home Secretary Theresa May, and was a response to a variety of other wider legislation changes, such as the Palermo Convention, and it created effectively this what we now call the Section 45 defence, that up until then had been in a slightly different format under the previous 2007 Act. And that specifically applies to people who are said to be the victims of slavery, trafficking or exploitation, which is quite broadly defined within the Act. However, one oddity of the legislation is it still doesn't define modern slavery, and still the best definition that I'm aware of and that many others are aware of is that provided by the NHS, which looks at the specific person and whether they are really a victim in the truest sense of the word. The NRM and Section 45 starts at a very early stage, and I'm not here to say exactly what to do in a police station. That's not the purpose of this webinar, but some of the issues that aren't immediately apparent are worth looking out for, because if a referral to the National Crime Agency or raising the issue of Section 45 or informing the police at an early stage can be done, then realising some of the red flags, such as lack of personal identification, lack of identification at all, no documents, being unwilling to provide what would normally be simple information, would suggest that someone has likely been operating in an area they wouldn't normally be in. Of course, I appreciate that people are often, when at that stage of interview, reluctant to discuss individuals they're in contact with, but this can be of varying degrees, and certainly in my experience when it comes to trial, those involved with Section 45 are extremely reluctant to discuss who may be their potential exploiters. And of course, it goes without saying, if somebody's in an area where they're not used to, so let's say county lines operations, for example, they won't be familiar with the local area, and that can sometimes be a red flag giveaway that Section 45 may become relevant. In terms of what steps to take, obviously, except normally these sort of cases result in no comment, because there is some sort of acceptance of criminal wrongdoing and some sort of acceptance of being involved. If possible, then Section 45 and duress can be raised in a police interview. If it can't, then it can be remedied in due course. If there is a social worker, which there quite often is, they are increasingly aware of the NRM referral, which I'm going to discuss at length shortly. It is their responsibility as a safeguarder to take those steps and to contact the various helplines, and they should be actively encouraged to do that, as well as, if possible, encouraging the police to take steps to protect the alleged suspect who may well actually be a victim. And even at this early stage, it can be useful, and certainly something I'd recommend, to consider involving what's called the National Referral Mechanism. And the NRM, as they're more commonly known, are a body of the National Crime Agency, and they go through effectively a three-stage process. And say the final stage is us. First of all, they've got 5 days to decide whether there are reasonable grounds to suspect someone is the victim of modern slavery, so trafficking, exploitation, or slavery. And that is a really low test, and a large number of people come back with a positive reasonable grounds test. And that's really helpful in the early stages, certainly for bail applications and for writing initial representations to the Crown. Once there is that reasonable grounds positive test, the decision's then referred to a further body within the NCA to complete what's called a conclusive grounds test. And that looks at a far greater amount of information, a far greater amount of evidence. And various individuals, including the CPS, the police, the defence, social services, can all provide information. And in my experience, it's fallen on the defence quite heavily to put together bundles of relevant evidence and information to put before the decision maker, because what they'll produce at the end is what's known as a decision minute, which basically says, here is our decision, you either are or you are not the victim of modern slavery, and provide a very brief explanation. That document is normally only 2 pages, and it should be provided to the defence. In terms of the third step in challenging the decision of the NRM, it is extremely difficult to challenge an NRM decision. And in my opinion, the only way to do that is either on grounds of unreasonableness, which is an incredibly high bar to prove, or by way of procedural impropriety, where they've applied the wrong test, applied the wrong information, or failed to take into account something which they ought to have done. And I think there'll be increasingly common challenges to NRM decisions going forward. And those can be either by way of judicial review or as part of a wider abuse of process application where the Crown continue to prosecute in light of evidence provided. In terms of the prosecution decision, there is a three-stage test that they have to apply, and there are a raft of policy documents that the CPS have drafted to determine when they should prosecute. So first of all, a simple question: is there a reason to believe that the person has been trafficked? And that means trafficked in simple terms of either trafficked, transported, or being the victim of modern slavery. Second, is there credible evidence of duress? Well, we understand the law on duress. Thankfully, the law under Section 45 has a much lower bar because of the shift in the burden of proof. Once that there is some evidence raised of exploitation or slavery, the burden is on the Crown to prove beyond reasonable doubt the defence under Section 45 does not apply. And so showing some evidence of duress is normally possible in these cases. The final one is effectively the nexus between the exploitation and the offending itself. And this is where the issue of charging becomes a little bit more complicated, because let's say, for example, somebody does have a positive NRM decision, but they're arrested for possession of bladed article. The Crown can say, and have said in various cases, the NRM referral does not apply to you carrying a bladed article because you're not doing it as part of your slavery. Certainly, I'm not sure I agree with that. And if that were to happen, certainly my view would be it's a case where you run it to trial under Section 45 and say carrying a knife is all part and parcel of the exploitation. And as such, someone in that position ought to be acquitted if the Crown can't disprove it. The Section 45 defence, as I've said, is simply on the defendant to raise sufficient evidence. And since the case of MK in 2018, the burden is then on the prosecution. The factors and characteristics that can be taken into account, there are several. The issue is that there's such limited guidance, apart from a couple of recent cases from the Court of Appeal, as to say what factors and characteristics are actually relevant. In respect of adults, again, a three-stage test, they committed the offences, they were compelled to do so. So some element of force, as we'd expect in duress. Where we start to differ from duress is that compulsion has to be attributable to slavery or relevant exploitation. And finally, the reasonable person, albeit this is a more subjective test because they have to have the person's relevant characteristics, would have no realistic alternative to doing that act. In respect of children, it's a lot lower. And that's why we're seeing increasingly children relying on the Section 45 defence, because it simply has to be a direct consequence of being a victim of slavery or exploitation. And then again, the reasonable person test as to having those relevant characteristics. So I've talked about exploitation and trafficking. What actually is it? Section 1 of the Act sets out all of these factors: slavery, servitude, labour, exploitation. And the final two are a little bit broader. It can be securing services by force, threats and deception, and simply securing services from children and vulnerable persons. The interesting part of those latter two, especially with charging decisions for actual substantive offences under Section 2, means that the Crown can be far broader in their application of modern slavery legislation. These are some of the relevant characteristics that have been considered. One to focus on is physical, mental illness or disability. That is quite a high bar. It has to be a recognised mental illness, and that's where expert evidence in cases such as this can be increasingly important. And as well as using actual medical experts as diagnoses, I've experienced the use of an expert in relation to modern slavery and how people react in terms of relevant characteristics, and that's Craig Barlow, who's based up in Northampton. In terms of how the courts approach these cases, the recent case of GB has made clear, as I spoke earlier, the importance is to focus on the nexus between the exploitation and the actual offending, and that's going to be increasingly the way forward. there is extremely limited guidance on approaching the decision minute of the NRM, and actually the decision at all. My view is that that decision minute should be admissible. The difficulty is that it's hearsay evidence, and so each case will tell its own facts until there is some firm guidance from the Court of Appeal. Certainly my approach would be to seek agreement in the form of a Section 10 admission as to what the finding was, rather than going into the background of what the actual factors considered were and the substantive explanation for the decision. In terms of a decision to prosecute, an extremely difficult area, an area that will continue to develop, the only area I can see to challenge that decision is where the CPS either ignore an NRM decision or they don't apply their own policy properly. And that is increasingly rare because those policy documents are so clearly drafted. And finally, to look at some appeal considerations, because I'm increasingly seeing cases where people have been convicted of offences but have subsequently realised that they may have had a defence under Section 45. And the first area, of course, is to look at under McCook, were they advised about Section 45? Did they know it existed? But in terms of if the matter proceeds to the Court of Appeal, there are 4 stages effectively. Was there reason to believe the defendant had been trafficked? Was there a sufficient nexus? And did the prosecutors consider whether it was in the public interest to prosecute? And turning finally to delay, the issue is whether they've been caused substantial injustice by the conviction, rather than the issue of delay being considered traditionally.
Hello and welcome to 2 Bedford Row's series of webinars. My name is Nick James and I'm talking to you about the duties of an expert witness in a criminal trial. This case stands as a stark reminder of the need for those instructing expert witnesses to satisfy themselves as to the witness's expertise and to engage an expert of a suitable calibre. Lord Justice Gross issued this reminder and warning in the case of Paybon in 2018, an appeal brought by a former Barclays trader after it was discovered that an expert witness relied on by the SFO had failed to comply with his basic duties as an expert. Yet the collapse of Operation Balaban, a carbon credit fraud trial last year, clearly demonstrated that the warning had not been heeded. Andrew Ager, an expert in carbon credit trading, was exposed by the defence to such an extent that the Crown could no longer rely on him. Having heard Mr Ager's evidence on a voir dire over 2 days, the trial judge, His Honour Judge Lorraine Smith, found that he was not an expert and that he had little or no understanding of what an expert's duties were or why they were important. So what can we as practitioners do to satisfy ourselves that our own expert is suitable and also to ensure that the other side's expert is complying with their duties? Well, the safeguards lay in the Criminal Procedure Rules Part 19, the Practice Direction 19A to C, and the CPS Guidance for Experts, which was updated in September last year as a direct result of the collapse of Operation Balaban. The guidance sets out in some detail the onerous duties placed on an expert witness and the potential consequences of failing to comply. It is worth remembering that Operation Balaban did not collapse due to Mr Ager's lack of expertise in or knowledge of his subject. It was because he failed to comply with or even to understand the most basic duties of an expert witness in a criminal trial. This is not intended to be an academic trawl through the safeguards. This is intended to provide some practical guidance on how practitioners can satisfy themselves as to the reliability and calibre of expert witnesses, be they experts called for the prosecution or the defence, or be they experts we're instructing ourselves or those that we are challenging. Because although the 2 cases highlighted concern prosecution experts, my own practice and experiences for the defence, the steps and checklists apply equally to prosecutors. It is vital that prosecutors satisfy themselves as to the calibre of their own experts, as well as those called by the defence. Although, of course, the same duties of disclosure do not apply to defence experts, the requirements of Criminal Procedure Rules Part 19 and the Practice Direction apply equally to defence experts and prosecution experts. A checklist for instructing or challenging experts. Number 1, know and understand the Criminal Procedure Rules, Part 19. Number 2, ensure compliance with the obligation to disclose matters capable of undermining the reliability, credibility, or impartiality of the expert. Number 3, consider the factors a court may take into account in assessing reliability. And number 4, confirm that the expert has complied with those relevant duties. The Criminal Procedure Rules, Part 19. Ensure that you are familiar with it, and ensure that your expert knows and understands their duties under Rule 19.2. Part 19 deals with expert evidence generally, and 19.2 specifically with an expert's duties to the court. These apply equally to prosecution and defence experts. These duties include giving an opinion which is objective, unbiased, and within the expert's area of expertise. The duty to inform all parties if the expert's opinion changes. And the duty to disclose matters which are capable of undermining the reliability of the expert's opinion or detracting from the credibility or impartiality of the expert. Indeed, Rule 19.3, subsection 3c, states that the party calling the witness must serve notice of anything which is so capable with the expert report. The practice direction lists examples of matters that should be disclosed under this rule, and we'll look at those now. One of the main criticisms of Andrew Ager was that he had in fact made an important concession during cross-examination in another trial since his witness statements in Operation Balaban had been served, yet he had not informed anybody of this. So as a practitioner, we must ensure compliance with the specific disclosure obligations. Criminal Procedure Rule 19.3, subsection 3c, requires the instructing party to give notice of anything capable of undermining the reliability, credibility, or impartiality of the expert. And Rule 19.2, subsection 3d, requires the expert to disclose anything to which this applies to the party instructing them. Practice Direction 19A.7 gives some assistance with a non-exhaustive list of things which notice should be given pursuant to these rules, and we'll look at some of those now. Examples given in the practice direction at 19A.7 include, as well as the more obvious matters such as criminal convictions or adverse findings from professional bodies, the examples given include fee payment based on outcome, adverse judicial comment, appeals allowed due to deficiencies in the expert's evidence, and a lack of accreditation or compliance with professional standards. It is important for practitioners to carefully consider requests for disclosure of such matters, because although the rules expressly state that persistent or disproportionate inquiries are not required, it goes on to say that the court will examine very carefully matters that come to light which have not been disclosed by either the party or the expert themselves, and that this may in fact lead to the expert's evidence being excluded. This can be found at 19A.7 of the practice direction. Consider the factors a court may take into account in assessing reliability. These can be found in the practice direction at 19A.5 and 19A.6. 19A.5 lists factors the court may take into account in assessing the reliability of expert opinion, whereas 19A.6 requires the court to identify specific flaws in the evidence which might affect reliability and lists examples. Familiarity with these will not only assist in any application to exclude evidence, but also in ensuring the reliability of your own expert witness. Defence practitioners will want to carefully consider any disclosure requests relating to these factors. Factors the court may consider in assessing reliability 19A.5. This is a non-exhaustive list, but includes the extent and quality of the data on which the opinion is based, the completeness of the information available to the expert, whether the expert followed accepted practices, and the extent of any peer review. In addition, in considering reliability, and especially the reliability of expert scientific opinion, the court should be able to identify potential flaws in such opinion which detract from its reliability, such as opinion based on an insufficiently scrutinized hypothesis, opinion based on flawed data, opinion based on unjustifiable assumption or conclusion. Finally, make sure the expert has complied with the relevant duties. 1, has provided a self-certificate. 2, has included a declaration in the report. 3, if a prosecution expert has provided an index of unused material. And 4, if a prosecution expert, that they have complied with their duty to retain, record, and reveal. The newly updated CPS guidance contains pro formas of 1, the self-certificate, and 3, the index of unused material within the appendices. The self-certificate must be completed on instruction by all prosecution witnesses, as per the guidance of paragraph 5 and appendix B. However, it's good practice for a defence expert to provide this also. It requires confirmation that the expert has read and is familiar with the guidance, and also confirmation as to whether or not any information needs to be disclosed pursuant to the specific disclosure obligations set out within the criminal procedure rules. A declaration must be included within the report of any expert, defence or prosecution. There is a sample declaration included in the practice direction at 19B, and it includes that there should be written confirmation of the following: the duty to the court to give unbiased opinion, that fees are not dependent on the outcome, that all sources of information relied on are included, that all facts that might adversely affect findings have been disclosed, and that nothing has been included or excluded on the suggestion of others, including by the expert's instructing lawyers, without the expert forming an independent view. There is also an obligation within that sample declaration to state that the expert has complied with all disclosure obligations. Of course, that is an obligation that applies to prosecution experts only. As indeed does the provision of an index of unused material, a sample of which can be found in Appendix B of the CPS guidance, and the duty to retain, record, and reveal. 4.7 of the CPS guidance makes it clear that retain, record, and reveal are the 3 key obligations in order that an expert witness can discharge their disclosure obligations. What that requires is set out in detail at 4.8 to 4.10, but one of the keys to this is that an expert is required to reveal everything they have recorded to the prosecution team. It is not for the expert to assess relevance for the purposes of disclosure. So finally, safeguards do exist, and they follow rigorously. Any inadequate or unreliable expert ought to be exposed. The danger is that if practitioners assume that all duties and obligations have been complied with, an expert can present themselves as unbiased, honest, and reliable when in fact they are not. These checks must be undertaken. It is also vital that defence teams carefully consider and make focused disclosure requests. Where the evidence of an expert is relied on, the defence must hold the expert and the prosecution to account. In most cases, the efforts will result in confirmation that the expert has complied with their duties and is of a suitable calibre. But as these 2 cases have shown, this will not always be the case. Let these cases serve as a stark reminder. Please feel free to post comments or questions you have about this webinar in the comments section below.
My name is Stan Reiz, and I'm to you about charging money laundering, and in particular, a practitioner's perspective to the Money Laundering Offences and the Proceeds of Crime Act. There are three offences, three sections creating offences under the Proceeds of Crime Act that are known as the money laundering provisions. The first is section 327. And a person commits an offence under this section if he conceals, transfers, or removes from the jurisdiction criminal property. Criminal property is defined by section 340 of the Act as constituting or representing a person's benefit directly or indirectly from criminal conduct. This offence is often used to charge sophisticated money laundering, and the classic example is a corrupt accountant who transfers client money to third parties in order to distance his criminal client from the source of the money, enabling him to effectively launder the proceeds. It's also, however, used to charge less sophisticated offending. One clear example is the drug dealer who uses the benefit he receives from his trafficking to purchase goods such as property or cars, jewelry. In doing so, he is both transferring and converting criminal property. The second common offence charged under the Proceeds of Crime Act is under section 328. This has a fairly wide ambit and is focused upon money laundering arrangements. It can cover all forms of sophisticated money laundering schemes. One example is the controlling mind behind a bureau de change, who facilitates the conversion of money for criminal customers in order to remove it from the jurisdiction or to facilitate the retention of that money. The final section under the Act that deals with the money laundering offences is section 329. And that is largely similar to the other two sections. It's different to section 328 insofar as it doesn't involve a money laundering arrangement being in operation. A person can commit a section 329 offence if he acquires, uses, or has possession of criminal property. That can be one individual who is simply using or dealing with the proceeds of his own personal crime. So there's no necessity for multiple offenders or an arrangement to be in place. The money laundering offences have been charged quite regularly since the Act was passed, and there are clear advantages to the prosecution in doing so. Firstly, a money laundering offence, even in instances where there isn't a classic need to charge it, can be advantageous because it's easier to prove. Since the case of Anwar in 2008, there's no requirement on the Crown to prove the specific crime from which the proceeds were derived from. Therefore, if there's a cash seizure and it's difficult for the law enforcement authorities to determine where the money came from, however, the circumstances are such that it can be clearly inferred that it must be from some unlawful conduct, the case of Anwar said that that was sufficient to achieve a conviction. In the case of GH, the more recent Supreme Court authority, that court sought to some extent to limit the circumstances when money laundering offences would be charged. Lord Toulson, at paragraph 48 in particular, said that it would be bad practice for the prosecution to add additional counts of money laundering unless there was a proper public purpose in doing so. He was referring to instances where the predicate offence could and is charged, but is accompanied by a supplementary money laundering charge. And the example that Lord Toulson gave was that of a thief. Someone who steals goods is a thief, but consequently, they are also a money launderer. Run away from the scene with a stolen item, the thief is possessing criminal property. When he sells it on, he is transferring and potentially converting criminal property. But what Lord Toulson said was that it would not be in the public interest, it wouldn't have a justified purpose to charge someone with theft and the associated money laundering, because the money laundering added nothing in those particular circumstances. So there had to be some additional criminality or some justifiable reason to charge an additional count of money laundering in those circumstances. The case of Ogden was decided by the Court of Appeal around the same time as GH, although it followed GH. Ogden was a case in which the Crown had accused a number of drug dealers with offences of conspiracy to convert criminal property. And the reason why they charged them with that particular offence is because they couldn't prove which particular drug they agreed to supply in every instance. So they took the choice of charging money laundering instead. And the Court of Appeal said, in those circumstances where there was a gap in the prosecution case, the Crown were right to charge a money laundering offence rather than charge a drugs offence. They went on to say that they had no doubt that the good sense of prosecutors would prevail and the money laundering offences that were charged in such cases would be done so appropriately. The case of Hack is a case I was involved in. Indeed, I was involved in Ogden as well. And in that case, the facts were slightly different because Mr. Hack was a money launderer on the Crown's case, and he was convicted of acquiring criminal property. There were fraudsters who were deceiving pensioners into paying money into the accounts of third parties like Mr. Hack. And whilst there was no evidence, no persuasive evidence that Mr. Hack was a fraudster, he certainly received money obtained from fraud. The sole ground of appeal was that there was no case to answer, as whilst Mr. Hack on the face of it could have been guilty of any number of offences under the Proceeds of Crime Act, including possessing criminal property and being involved in a money laundering arrangement. He wasn't in fact guilty of the one offence that he'd been charged with, which was acquiring. And the reason for that was that the money was paid into his bank account from a legitimate source. There was no suggestion that the victims had any illicit funds, so their legitimate money entered his account. And at the time it entered his account, it was not criminal property. It only gained its criminal character once it was received. And therefore, whilst he was in possession of criminal property, he couldn't have been said to acquire it. And that's what Lord Justice Davis said at paragraph 24, when he stated that in cases of this kind, the property in question must be criminal property prior to the transfer in question. The transfer cannot of itself suffice to make it criminal property. And he then went on to emphasize the point that further dealing with the money can be consistent with other methods of committing the offence, but it could not be an acquisition. He made the point at the end of the judgment that it was very important for practitioners to take great care to ensure that money laundering offences are charged appropriately, and failure to do so could have serious consequences, as the case of Hack proved, because the Court of Appeal, albeit reluctantly, quashed Mr. Hack's conviction. The court also observed at paragraph 31 that the explanatory notes of the Act seemed to treat the money laundering provisions as containing one offence in each of them. However, they felt that that was questionable because in particular sections 327 and 329 on their face are worded and structured so as to connote ostensibly different offences. Now that was potentially highly significant because, as many practitioners will know, money laundering offences like section 327 are often charged in a very broad way. For example, concealing, converting or transferring criminal property, and the indictment says just that. Those charges framed in that way now, based on the observations in Hack, could be bad for duplicity because they would tend, if Hack is correct, to be charging different criminal offences in one count, which is not permitted. So the points to remember when prosecuting and defending money laundering cases are: one, that there must be a proper public purpose to add additional offences of money laundering to an indictment. It cannot be done as a matter of course. There has to be proper consideration. Two, if it is necessary to do so, care should be taken to ensure that the correct charge is identified. And three, in deciding which offence to charge, it's important to understand that property must have its criminal character prior to the conduct which the money laundering offence reflects. The transaction by which the money is laundered is not enough of itself to give the money or the property its criminal character. The one exception that I've included as a footnote is that a money laundering arrangement can exist before the money becomes criminal property, but that's a slightly different point in this context. But certainly for sections 327 and 329, it has to be criminal property before. So for prosecutors, it's important to take great care when considering charging money laundering offences, and for those defending, indictments must be scrutinized so that clients can be given the correct advice, and submissions should be made and can be made at the right and timely opportunity.